Okay, so before I share my screen, how many of you know about patents? You have some idea about patents? Anybody? Meghna, Shilpa Shri, what is a patent? Shilpa Shri? Okay, fine. Uh, no worries. Please remember, everybody, whenever you invent something, whenever you make something really new, for example, during COVID-19, some of the companies made some vaccines. For example, Serum Institute was selling shield. Bharat, uh, Bharat, Bi Bharat Biotech was selling. Uh, what was the name of the vaccine of Bharat Biotech? Anybody know? What was the second vaccine that was available in India other than Covishield? What was the name of the vaccine?
Covaxin.
Vaccine, right? So Bharat Biotech was making and selling vaccine, right? Now, if let's say I am a pharmaceutical company and I am doing research on COVID vaccines, and I make up a vaccine, I come up or I invent a vaccine that can cure or that can treat COVID-19. So obviously, I want to make use of it so that only I can make it and I can sell it in the market. Nobody can copy it, right? Because in India, if something is successful, right? If a product is very successful, each and everybody wants to copy that and sell in the market so that they can also make profit out of it. To prevent such a scenario where if I have invented something and I want that only I can make it and I can stop others from using it or making it without my permission, then to protect my invention, I can go to the Patent Office of India, which is a registered department of Indian government, and I can file for a patent application. I can go there and submit a document. I can go there and submit a document where I can say that this is my invention and I want you to give me a patent. If they approve it, they will give you a patent and you will have rights so that only you can use it, you can make it, others cannot use or make it without your permission. Is this clear, everybody? Samriddhi, is this clear? Naga, Revati, is this clear?
Yes, sir.
Okay, I'll again take one more example. Okay, so now let's say I am uh, I am Mankind Pharma. Okay, I am Mankind Pharma, a big a big pharmaceutical company in India. Now we have a research team in Mankind Pharma who are working on cancer treatment, okay, cancer medicines. Now we have come up with a new type of medicine or with a new type of treatment that can make chemotherapy less painful and easy. Okay. So, Samriddhi, what is my invention? What is my invention, Meghna, Sangeeta? What is the invention that I have just talked about?
It is a
You have
treatment,
created
chemotherapy,
you have
medicine.
created a treatment that is less painful to the patient.
Okay. So now, chemotherapy is generally very painful, very costly. It is time taking, right? So, as a Mankind Pharma, uh, hypothetically, we have developed a new sort of therapy which is less painful, less costly, and very easy to treat or to cure cancer. Now, as Mankind Pharma, I would want that only we should be selling this therapy, we should be making profit out of it, and we should be making it available to the public of India. Obviously, chemotherapy, if it becomes very simple, very easy, other companies would also want to do the same thing. So they can copy our invention. To prevent that, what Mankind Pharma will do is they will go to the Patent Office of India. They will go to the Patent Office of India and they will submit a document which will have details of all the information and details of the treatment of the chemotherapy treatment, the new chemotherapy treatment that they have discovered. And they will ask that please provide us a patent. Please give us a patent. If they are given the patent, they will have the sole ownership rights, monopoly over the treatment in which only they can make it, they can use it. If other companies want to use it, make it or sell it, they have to take permission from Mankind Pharma first. Is it clear, everybody?
Yes, sir.
Okay. And now, once you submit the patent application to the patent office, once you submit a patent application to the patent office, there are people, there are people, there are government employees, just like you and me, who are technical people. They are government employees and they receive your patent application. They will receive your patent. Then they will check whether your patent is really novel or not. Is it really unique? Is it really novel? Is it something that is essentially made by you and is not and does not exist earlier? If they think that it is, they will give you the patent. They will grant you the patent and they will give you the rights. And the people who work in the patent office who do this checking, they are known as patent examiners. They are known as patent examiners. And I believe some of you who have joined this class today, some of you are already preparing for this exam because in September there is an exam where you where you can if you clear the exam you will become a patent examiner and you will be working in the in the Indian Patent Office to check such patent applications as a patent examiner. Okay, so I think some of you, Lakshmi Shri, are you appearing for the patent examiner exam? Yes or no? Sylvia, I think some of you are already appearing for that exam. So that is the work that you are going to do at the patent office. Now, since we have now understood what is a patent, so let's say I invented something, I got the patent. I got the patent. So everybody, now I will share my screen quickly. Just give me a second. Okay, I need to stop sharing. Okay. So is it possible that I will get the rights throughout my life? So I invented something today, I got the patent today, and let's say I have a 30 years life remaining or 50 years life, right? So would I have the rights for the rest of my life? No. The answer is no. Once you get the patent, once you get the patent, you will get the protection for only a limited period of time, which is 20 years, which is 20 years, 2020. So it means that if you get the patent, if Mankind Pharma receives the patent of chemotherapy treatment, they will receive the protection for 20 years. Means till 20 years, nobody can use it without their permission, without their authorization. But after 20 years, all the companies in India can make the same treatment without asking for their permission. Is it clear, everybody? Yes or no? Quickly. I need to hear yes from everybody.
Yes,
Yes, sir.
yes, sir.
Okay.
Yes, sir.
Okay. Fine. Now, when you go to a market and buy a medicine, for example, right? You go to a market, you go to a chemist, you buy, let's say, a medicine for cold or flu or cough or fever, right? Some of the medicines you would hear this term patented medicine and generic medicine. Have you heard this term patented medicine and generic medicine? Have you heard this term?
Yes, sir.
Yes, sir.
In the chat box, I am typing. You if you haven't heard, you will hear it in the future. Patented medicine and generic medicine. Okay. So now what does this mean? Generally, what happens is if Mankind Pharma developed a medicine, obviously they will file the patent for it, and if they get the patent, that becomes a patented medicine. It means only they can make it, they can sell it. And generally, just think in your mind, if I am the only one in India who can make a medicine, obviously chances are there that the price that I will keep of that medicine will be a bit high. Yes or no, everybody? If only I am making it, chances are there that I will keep the price a bit high.
Yes.
So till 20 years, this might be a possibility. This might be a possibility that till 20 years, since I have the power for 20 years, I might keep the price a bit high. Okay. And in the future classes, I will tell you that Indian government has a mechanism of preventing it. We will discuss it in some other class, but for today, only I can make it, so I might keep the price a bit high. But after 20 years, when my protection is over, since I don't have any right after 20 years, then all the companies will make it, competition will be there, so the price will come down. So till 20 years, the medicine will remain a patented medicine because it has a patent associated with it, and after 20 years, it can become a generic medicine. One other difference is, for example, I, as a Mankind Pharma, has developed a chemotherapy medicine, right? I have the patent, so it becomes a patented medicine. But some other company did not use the same drugs or same compound that I used in my invention, right? So, for example, I used drug A and drug B in my medicine. Now, company B, there is some other company, they used drug A, but they did not use drug B. Instead of drug B, they used drug C, which is same as B, which provides the same function as B. So now my invention has A and B, but the other company has made medicine using A and C. So that can become a generic medicine. That can become a generic medicine. So my competition of A and B will be with the other company who is selling a combination of A and C. Is this clear, everybody?
Yes, sir.
Yes.
You have to say yes or no, everybody. Meghna, Sangeeta, Madhura, Sonali. You have to say yes or
Yes,
Yes,
no.
sir.
sir.
Okay,
Yes, sir.
great, great. Now, please let me know once my screen is visible to everyone.
Yes,
Is
sir.
it visible now?
Yes, sir.
Yes, sir.
Okay, great.
Yes, sir.
Yes,
So
sir.
what is a patent? A patent is nothing but a set of exclusive rights. Why is it exclusive? Because it is given only to me, the inventor. It is a set of exclusive right granted by a sovereign state. Sovereign state is nothing but Indian government to an inventor for a limited period of time. The right is given for a limited period of time, and the time is typically 20 years from the filing date. So if I file it today and in the future I get the patent, the protection will be 20 years from the filing, right? It is a right, means a legal right. Why it is a legal right? Because let's say, why are we saying exclusive right granted for an invention, right for a limited period? What is a right? Right? So now, right is nothing but a legal right. So, for example, Sangeeta has a patent, and a big company is using the same invention without Sangeeta's permission. So Sangeeta can go into the court of India, High Court, Supreme. She can go and ask the court to punish the other company, to take money from them, or to stop the product of the other company. That's why a patent is nothing but a legal. Is this clear, everybody?
Yes, sir.
Okay.
Yes, sir.
Yes.
Have you heard the company Canva? Canva, Canva. Have you heard about this company Canva?
Yes, sir.
It is the
No,
world's
sir.
okay. It is the world's largest company for digital marketing. In simple language, you can make posts, you can make videos, you can do all type of stuff, and it is one of the biggest company in this space in the world. Last week in India, what happened was there is a small similar digital marketing company in India. Okay, I am forgetting the name of the company, but there is an Indian company. Okay, and that company, Indian company, has a patent, Indian patent of a specific functionality. So in their product, the Indian company has certain functionality, such as, let's say, for example, they have a functionality where you can edit a video or a photograph in a certain way. Now, Canva has the same functionality in their product. Canva company, who is the biggest company, has the same functionality in their product. And people in India using Canva are using that feature. So now what this small Indian company did is they went to the High Court of India. They went to the High Court and they proved that we have the patent and Canva is using the same functionality as it is disclosed in our patent. So High Court of India and Court of India also will give this verdict in some time. But High Court of India has asked Canva to remove that feature from their product. Has asked Canva to remove their product, this feature from their product. This is the power of patent and this is the legal right. Is this clear, everybody?
Yes, sir. Yes, sir.
Yes.
Yes, sir.
Great.
Yes, sir.
So now we understood what is a patent. Basically a patent is nothing but a document. And once you get that document, once you get that approval from the patent office, you get exclusive rights for 20 years. What is the right? A patent protects an invention. It gives the holder, means the inventor, an exclusive right to prevent others from selling, making, and using the patented invention. So, how many of you have seen? How many of you have generally seen Shark Tank? Have you seen Shark Tank?
Yes, sir.
There was a product in
Yes,
Shark
sir.
Tank. There was a product in Shark Tank this season, Janitri. Have you heard about Janitri? Anyone?
No, sir.
Just give me a second, I'll show you.
No, sir.
Just give me a
Yes,
second,
sir.
guys, I'll show you. Just give me a second. Okay, I'll share my screen and I'll show you the power of patents. Real-time example. Can you see my screen, everybody?
Yes, sir.
Okay, so
Janitri.
this company
Yes.
Janitri, they make a product pregnancy monitoring product. Okay, which can be given to a pregnant woman and all the monitoring is very easy. The founder of this company was my my team member in one of my previous company. Okay, and this company came in the Shark Tank this season. Okay, now in the Shark Tank episode, he told that he has several patents of this product. He has several patents of this product. Now, what does this mean? It means that his product is patent protected. No big company, no big company can copy their product, can copy their technology without asking their permission. This is the power of patent. That's why in pharmaceutical companies, in all startups, they are going after patents, and because of that, because of the increasing number of patents in India, Indian Patent Office has opened 5 post government Gazetted level positions for which the exam is going to take place in next month in September. Is this clear? Patent is clear, everybody? Yes or no?
Yes, sir.
Great,
Yes, sir.
great. So now I want everybody to read the last 2 bullet points. Please read the last 2 bullet points. Is this clear? The 2 points. These are the right
Yes,
to
sir.
right. If anybody has any doubt, please ask me. So shall I move ahead? I need a yes. Or if you have any query, please ask. I am going a bit slow because this is the first class. Okay. I believe that everything is clear. So now, let's say I am a researcher, okay, and I invented something. But is it necessary that if I have invented something, so I will get a patent? The answer is no. The answer is no. It means every invention will not get a patent. Every invention will not get a patent. Only some of the inventions will get the patent. And the reason is, if your invention, if the invention that you have made is novel, means it is completely new. It is completely new. It is nowhere disclosed, published anywhere in the world. Only then you will get a patent. Your invention is non-obvious. Your invention is non-obvious. It means, let's say you invented something, and Sangeeta, you are a PhD, right?
सर ने मना किया है.
Yes, sir.
Okay, in which domain?
Biotechnology.
Biotech. Okay. So Sangeeta is a PhD in biotechnology. Now let's say I invented something in the domain of biotechnology, and when I showed it to Sangeeta, she says it is very obvious. This invention is very obvious, right? Anybody who has a knowledge of biotech, it will be very obvious to you. So if your invention is obvious to an expert, then you will not get a patent. Now you must be thinking that obviousness is very subjective, right? Something that is obvious for you might not be obvious for me, right? So please remember, to prove obviousness, you need to give facts. You need to give facts. But again, if the patent office says that yes, your invention is obvious, then you will not get the patent. So the patent office has to say 2 things. First, your invention has to be novel, it has to be new, it has to be unique. Second, your invention has to be non-obvious. Okay, and third, your invention has to be useful. Means it should be capable of being used in any industry. So now, for example, I made a device, or I made a drug that can, if if you taste it, you will be dead. So for example, I made a drug. If you taste it, you will you will be dead, right? Now I can prove that it is unique, it is novel, and I can prove the non-obviousness, means it is not obvious. The third thing I need to prove is it is capable of being used in an industry. So now the patent office might say, hey, if you get a patent for it, means you will make it and people will taste it and they will be dead, right? So maybe I can prove that in hospitals or in prisons, in jails, right now people are hanged or people are electrocuted, right, to kill. So rather than you hang a person, you can give this drug to the person and he will be killed very easily. He will be dead very easily. So I need to prove the applicability. But three things has to be there in the invention. What are the three things? Nagar Revati, what are the three things? Anybody? Sylvia, what are the three things in the invention that should be there to have a patent?
First one is novelty.
Yes. Second. Second is
Second is non-obviousness, and the third is capable of industrial application.
great. Good. So three things has to be there in your invention to get a patent: novel, non-obviousness, and use. Now, now, let's say this is my phone. Okay, this is my phone. Now, this phone has a software application, has an operating system. Now, that operating system might be giving me some, or might have some novel features. For example, let's say image editing, or when I receive a call, this phone might have much more clarity than other things, right? So if I talk about these features, these are nothing but the functionality of the yes or no, yes or no. These are the functionality of yes or no. Quickly, yeah.
Yes, yes,
Yes,
Yes.
sir. Yes, yes.
The second thing is, for example, I am the designer. I am the designer at Apple, right? And I designed iPhone in a unique way. So that design of the iPhone will have a unique feature, right? So first that I talked about was about the functionality. So if you invent something that has a new functionality or that has a new process, that has a new method. Second is you invent something that does not have any functionality but that has a unique design, right? So you can file patent for each. You can file patent for each. So now just to give you one more example, I am a designer or I am a device manufacturer company and I invented uh, how many of you know about inverter that we have at home? Inverters. Do you know about inverters?
yes,
Yes, sir.
Right. Inverter is when electricity goes off, inverter comes into the picture and it provides you the electricity. So I am the inventor of an inverter. Generally, inverters are bulky or big. Yes or no, Sangeeta? Inverters are big in size.
yes, yeah,
So I am the inventor and I invented an inverter that is of the size of this phone. That is the size of this phone. Okay, I am the inventor and I have invented a new type of inverter which is very small in size. Now the functionality of the inverter, how it is producing the electricity, how it is storing the electricity, all those functionality, I can file a patent for it. But I know this design is very important for me as well. So I can file a patent for a design as well to protect the design so the design cannot be copied. Accordingly, you will have two types of patents. First is utility patent. Utility patent is protecting the inventions which provide useful functions. So the first, inverter's functionality. If I want to file for it, I will file a utility. Example, a method to reduce noise in telephone calls. So if I have invented a method that can reduce noise in telephone calls, that will be a utility patent. And life is 20 years. Second is design patent. Design patent is nothing but protects only the design. Only the aesthetic reason, only the appearance, no functionality. And they have a life of 14 years. They have a life of 14 years. And okay, forget it. It has a life of 15 years. So utility patent has a life of 20 years. Design patent has a life of 15. Oh, I'm sorry. Utility patent has a life of 20 years. Design patent has a life of. Is this clear, everybody?
Mm.
Yes,
Yes,
sir.
sir.
Great,
Yes, sir.
great,
Yes, sir.
great. So now the next question comes: who can apply for a patent? Who can apply for a? Obviously, if I am the inventor, I have invented. So obviously, now my father or my mother will not file the patent unless and until I authorize them. So patent can be filed in India by the inventor who has invented the application invention, and the assignee of the invention. Who is the assignee? So let's say Tamanna, for example, Tamanna is a researcher in Tamanna is a MSc or MTech student in a university, and she is doing her research in the college. Obviously, all the resources, money, everything is provided by the college. So now, when she invents something and when she files in the patent office, she will be the inventor. Tamanna will be the inventor, but college will say, "Hey, we are paying you the money. We are funding you. So we will file the patent in our name." So assignee is the person, assignee or applicant is the person who files the patent, inventor is the person who invents it. Is this clear? Are these points clear, everybody?
Yes, sir.
Yes, sir.
Yes, sir.
Great, great. Anybody has any doubts so far? Please ask if any. Okay, so I believe that everything is clear.